both in the committee meeting room, staff, and following along online, and ask for a bill brief from the reviser. So either Mr. Thompson or Ms. Scott, whoever wants to go first. And if it's up to you guys. Thank you.
Thank you, Madam Chair. So in front of you guys, you have this stapled conference chart. This represents the bills that are before these two committees in conference committee right now. You also have a single page chart, which represents the bills that have passed one chamber, but are not currently in a bill that's before you in conference. So since the Senate bills touched the House last, I'm going to go through those, and then Jason's going to go through the House bills and explain the Senate changes. So first we have Senate Bill 174. This ended up being our kind of mega criminal bundle here. So when it came over from the Senate, it increased the criminal penalties for interference with law enforcement officers when that interference is fleeing from a law enforcement officer. And the current Senate Bill 174 does retain that provision. It is in Section 6. And so no substantive changes were made there. But then the House did add several provisions to this bill. So they added a new Section 1, which creates the crime of interference with the conduct of a healthcare facility. That came from House Bill 2023. They also added Section 2 from House Bill 2023, which increases the penalty for battery of a healthcare provider. And then Section 3 amends KSA 215701, which adds a definition of a fentanyl-related controlled substance. It also includes putting substances into pills into the definition of manufacture, and then it excludes certain testing strips from the definition of drug paraphernalia. Section 4 brought in Section 2 from House Bill 2398, which increases the criminal penalties for manufacturing a fentanyl-related controlled substance. And then Section 5 added Section 1 from Senate Bill 73, which adds domestic battery and violation of a protection order to the list of crimes a person can intend to commit for the purposes of burglary and aggravated burglary. We went over Section 6. That was the underlying bill. The House didn't make any changes there. Section 7 brought in Section 3 from House Bill 2398 and created a special sentencing rule for manufacturing a fentanyl-related controlled substance. And then finally, Section 8 amends KSA 75702. This is Section 1 from Senate Bill 244, which gave the Attorney General concurrent jurisdiction to prosecute crimes that occur in 2 or more counties. So that's the first bill you have before you. Next, we have Senate Bill 217, which includes the conduct of utilizing an electronic tracking system or acquiring tracking information to determine a targeted person's location, movement, or travel patterns throughout several provisions in the code. The House Committee on Corrections just changed the effective date to be in the Kansas Register instead of the statute book. And then on the floor, there was a floor amendment to include the contents of House Bill 2029, which makes some changes in both the protection from abuse and protection from stalking, sexual assault and human trafficking acts. It increases the initial time for those orders and the possible extensions under those two acts. So that's how it is before you now in conference. Senate Bill 228 is kind of the county jail bill that you guys both heard. This requires the Secretary for Aging and Disability Services to reimburse counties for certain costs when a person is in county jail awaiting certain examinations. And then it updates related jail statutes throughout the sections. When it came over to the House, they made a few changes. The first was in new Section 1. They removed the requirement that the inmate be in, quote, the custody of the sheriff, because in some counties, the jail is not actually run by the sheriff. So kind of a more technical type of change there. In Section 3, the committee removed the definition of sex. And then in Section 12, they clarified that the custody and cost provisions they kind of separated those out. The Senate amendment that was made, they separated that into two paragraphs for clarity, and then they excluded bail agents from the definition of an arresting agency. And then Senate Bill 73. You'll recall that the substantive section of Senate Bill 73 was put into Senate Bill 174 as part of the crime bundle. And then the House committee inserted the contents of House Bill 2021, which allows evidence-based program account money to be used on certain children. It also requires the Department of Corrections to build data systems. It allows for overall case length limit extensions and detention sanctions for probation violations. So that contents was put into Senate Bill 73 and sent to you all. And I think that was the last Senate bill. Oh, yeah. And yeah, I guess we can go into House Bill 2021. So on the Senate side of that, they did work that bill, but they did make some changes to it. So they removed the new Section 1, which required the Secretary of Corrections and the Secretary for Children and Families to enter an MOU to assess juveniles for participation in evidence-based programming. And then Section 2 and 3 remain the same. So they amend 382203 and 382304 to require those agencies to collaborate when providing services to juvenile offenders or children in need of care. The Senate removed the provisions in KSA 382361 related to changing the detention cap from 45 to 90 days. They also removed the provisions in 382391, which would have allowed for the overall case length limit extensions. And they removed the new detention provisions in KSA 382392. They also removed the provisions in 7552-162, which would have required the Department of Corrections to develop a system to exchange confidential data between the different parts of the system. And then in 7552-164, they maintained many of those provisions, but they did remove the reference to the children in need of care since they took out the new Section 1 provisions. They expanded who can offer those evidence-based programs. They prohibited child welfare case management providers from receiving grants under the grant program that's created. And they provided that the grants are to be made after other expenditures from the evidence-based programs account.
Okay, and I'll pick up with the rest of the House bills. And if you follow along with these charts over the years, like some people in the room do, you'll notice those are not in numerical order. We put those two right in the middle on purpose, so they'd be right next to each other. So there you go. It was difficult for me. So yeah, it's the chart's got to be in order. But this was a very effective way. And then Natalie could talk about them both before I had to jump in with more House bills. So even better. The next House bill then, going back to numerical order, Senate sub for House Bill 2010, and this is the Senate's criminal bundle. So as amended by the House committee, it came over with just the cross references to KSA 223220 being changed to KSA 215209, the bill introduced by Representative Heiberger. So the Senate substitute for that bill does retain all of those provisions. So Section 1 is Section 1 of that bill, Section 5 is Section 2, and Section 6 is Section 3. So all three of those provisions are retained. Then the Senate added as Section 2 a provision from Senate Bill 183 that makes some technical changes to the crime of criminal discharge of a firearm. And I call them technical because it's really a restructuring so that it can then be used for a special sentencing rule that's in the next statute. So the crime itself doesn't really change much at all. Then in Section 3, there is a special sentencing rule pulled from Senate Bill 183 that would elevate the sentence for criminal discharge of a firearm when a person was present in the dwelling, building, structure, or motor vehicle at which the offender discharged a firearm. So there's a special sentencing rule that enhances that sentence by a number of months, depending on who was inside the building or structure or vehicle. The other provision added in Section 3 is from Senate Bill 193 with committee amendments, and this is the Reduce Armed Violence Act that you've talked about for the last couple of years. I note it is similar to House Bill 2031, but it covers fewer crimes. So it is much the same as 2031 in substance, but less crimes are covered as the definition of violent crime, I think is the term. Yeah. So, but it still increases those penalties, makes them presumptive prison, and makes them run concurrent to the underlying sentence. So, and then in section 4, the Senate added the provision from House Bill 2070. This is the one from the Sentencing Commission that allows certain non-drug offenders to participate in the Certified Drug Abuse Treatment Program, the Senate Bill 123 Drug Treatment Program. And then in section 7, the Senate added the provisions of House Bill 2069, which is another Sentencing Commission bill that provides that post-release supervision does not toll except as provided by law. So if you want the quick tracker on the left there, this has all of 2010, 2069, 2070, 183, and 193. That's where all those pieces came from. Question?
Sure, go ahead, Representative Heiberger.
This one. Can I request that for tomorrow that we get a little more detail on the differences between SB 193 and 2031, in terms of the crimes that are included and not included?
Certainly.
Okay, thank you.
Put together a comparison of the two crime lists. I just noted in for purposes here that it's fewer crimes, but yeah, we can get into details. Sure.
Another question on House Bill 2031. That was below the line. It didn't make it above the line in the House, or did it? It was below the line, and then it was stricken from the calendar. Okay, thank you.
House Bill
2031.
Correct. Yeah, your version in the House never did get above the line, right? It came out of committee, so you were aware of it. But yes, correct. Okay, moving then to House Bill 2214, a little bit easier here. This one changes the name of the Larned Correctional Mental Health Facility to the Larned State Correctional Facility, and removes a couple of references to facilities that do not exist. And all the Senate did was change the effective date to Kansas Register. And then the last bill is House Bill 2350. This is the bill that creates the crimes of human smuggling and aggravated human smuggling. I kind of outlined the 3 major points that it defined human smuggling, it defined aggravated human smuggling, and then the penalties. I'll start with the easy thing. The penalties didn't change in the Senate. So that's the last note, the same penalties. But Section 1, defining human smuggling, was restructured and substantially amended so that it reads like what is in the box there. Intentionally is still the culpability term, so no change there, but intentionally transporting, moving, concealing, harboring, or shielding from detection an alien with knowledge or reckless disregard of the fact that such alien has come to, entered, or remains in the United States in violation of the law in exchange for anything of value. So the value element is retained, the transporting, moving concepts are retained, and the intentional concept is retained, but some of the language in there you'll notice is substantially different. Aggravated human smuggling was also changed. It basically removed all options for aggravated human smuggling regarding deadly weapon or bodily harm, and just retained the human smuggling that causes the individual being smuggled to become a victim of some other offense that's listed there. So the House version had 3 different elements that could be satisfied, and the Senate version just has the one. And then finally, the Senate has a couple of provisions pulled from federal law. One, that the crime does not apply to transporting, etc., an alien that is expressly permitted by federal law, or to a religious denomination or a nonprofit religious organization that encourages, invites, allows, or enables an alien who's present to perform the vocation of minister or missionary for the denomination or organization. So 2 pieces from federal law that are in their similar crime that are adopted into the Senate bill. And finally, a provision also referencing federal law that says the determination of whether someone is here in violation of the law is to be made by the federal government under 8 U.S.C. 1373 and not by a local official. I think that's it.
Thank you. I have a quick question going back to Senate Bill 217, and the House version amended House Bill 2029 into it, And 2029 had a hearing, got out of committee, and then was stricken from the calendar where it was below the line. Do I have the chronology correct? Or the procedure correct?
Madam Chair, yes, House Bill 2029 was passed out of the Committee on Judiciary, actually, and then it was stricken from the calendar.
Thank you. Any other questions for the revisers? Yes, go ahead.
And you could just give me a quick explanation of that last paragraph on 2350 about determination of whether determination of alien status. How does it work at time of arrest? And I know I could probably read the language of the bill, but I'm not.
Sure, that was an amendment that was made at the request of the Attorney General, and the reviser could explain more the details of how logistically it would work.
Madam Chair, I'll attempt to recall how the Attorney General explained all of that. Essentially, the federal provision referenced there, 8 U.S.C. 1373, says that only the federal government will determine legal status. So that was one point of including the language, was just that you should use the normal procedures to determine whether someone is here lawfully or not, or you'd probably be in violation of federal law. The other piece was apparently by referencing that statute, that's the normal process for calling. I guess it's ICE now that you're calling. It references another entity in the statute because it's outdated, but that reference has been updated to be the current Immigration's Customs Enforcement Agency. But essentially, you reach out to them and they're going to tell you whether or not the person is here lawfully or not, if they know. That's really the key thing we heard, I think.
So that would happen before charging.
Sorry?
Before charging.
So, and the representative asked about charging for anybody who couldn't hear. That one I'm not perfectly clear on, because at arrest, you're making one determination. At charging, you're making another determination. So there might be two different things you're looking for there. And the mechanics of that are maybe a little beyond what I know at this point.
Thank you. Committee, other questions for the revisers? Okay, seeing none then, I think then the plan is to meet upon first adjournment of the second chamber tomorrow morning. And I think we're in 282 North, 218 North upon about 10-15 minutes after first recess of the second chamber tomorrow morning. So great. Well, thank you very much, everyone. We are adjourned.